So now I'm going to talk to you about filing and preparing the summons and complaint. The plaintiff who is seeking the unlawful detainer will prepare the summons and complaint with the court in the county where the property sits against the persons who are renting, which are called the defendant. There could be more than one defendant, even if only one tenant is listed on the lease or rental agreement. The summons includes the name of the parties, informs the defendant that the defendant is being sued, requires the defendant to file a written response with the court. In essence, the summons is summoning the defendant to court. Now, I say the plaintiff is usually the landlord, with one caveat. In the event of a sublease, the plaintiff is actually I'm going to go back. The summons includes the name of the tenant. Start over. All right, this is 2. The summons includes the name of the parties, informs the defendant that the defendant is being sued, and requires the defendant to file a written response with the court. In essence, the summons is summoning the defendant to court. Now, I say the plaintiff is usually the landlord with one caveat. In the event of a sublease, the plaintiff is actually a tenant who subleases to a subtenant. So in that case, the plaintiff would be the tenant who is subleasing to the subtenant and trying to evict the subtenant. Documents required. The 3 documents the plaintiff will need to file to begin the unlawful detainer process are as follows: the summons, the complaint, and any additional local forms. So I'm going to talk about the summons first. The summons is a notice to the defendant that the defendant is being sued and needs to respond. Under the new response rules for personal service of the summons and complaint, the defendant has 5 court business days, i.e. not counting weekends and court holidays, to file a written response with the court and have a copy of the response served on the plaintiff. 2. The complaint, also known as the Form UD-100. The next document after the summons is called the complaint. The complaint is where the landlord, i.e. the plaintiff, explains the basis for the eviction and why the landlord should be entitled to possession. The complaint also states who owns the property, what damages are being demanded by the plaintiff, and where the specific property is located. The landlord has to attach 3 things to the complaint. 1. The rental or lease agreement. 2. Any notices sent to the tenant or defendant. And 3. The proof of service. So I'll say again. The landlord must attach 3 things to the complaint: the rental or lease agreement, any notices sent to the tenant or defendant, and 3, the proof of service, if applicable. If no notice has been sent, for example, the unlawful detainer is being filed due to an expiration of a fixed term lease, then no notice would be required unless in a rent-controlled jurisdiction. Always make 2 copies of the summons and complaint, which I will discuss next. Take the 2 copies plus the originals to the courthouse. Again, you need to ensure that you are filing in the correct court, which would be the one located in the county where the property is located. Take your forms and copies to the court clerk to get the clerk to stamp them as filed. You'll have to pay a filing fee in order for the clerk to do this, in the following amount, or none at all, as I will discuss in a moment. Next, the clerk will stamp and return the copies, and the court will keep the originals and give you back the 2 court-stamped copies. You will keep 1 copy and give the other copy to the tenant. If there are multiple tenants, you should make copies of the court-stamped copy. Filing fee. The fee the plaintiff will have to pay to the court to file the unlawful detainer is a sliding scale based on the amount the landlord is seeking in total damages. Under the statewide civil fee schedule, which takes effect January 1st, 2020, the amounts are as follows. There will be a fee of $240 if the landlord is requesting less than $10,000, which is limited civil. There will be a fee of $385 if the landlord is requesting $10,000 to $25,000, which would be limited civil. And there will be a fee of $435 if the landlord is requesting more than $25,000, which would be considered unlimited civil. Fee waivers. If the plaintiff or defendant cannot afford a filing fee associated with the unlawful detainer, then either party can request a fee waiver. You may qualify for a fee waiver through one of the three following methods. First, if you receive public benefits, such as Medi-Cal, food stamps like CalFresh, CalWorks, General Assistance, SSI, Tribal, TANF, IHSS, etc. Two, if your household income before taxes is less than the amount you calculate on the court's information sheet on waiver of Superior Court fees and costs, which would be Form FW001 info. Or three, the court simply makes a determination that you do not have enough income to pay the basic needs of your household and the court fees. Lastly, well, second to last, there will be a civil case cover sheet, which you'll have to complete, and that's a Form 010. And there may be additional local forms. So ask the court clerk if any additional local forms apply to you. Keep in mind that some jurisdictions throughout California require these local forms, in addition to the standardized SUM 130, the UD 100, and the CM 10, which are all standardized forms. Thank you for watching. I hope that helps.